guests, it is my privilege to interview Simon Mulongo, a remarkable Ugandan figure whose career has left a profound impact on various domains in Uganda. In 2005, Simon Mulongo graduated with an MA in Strategy and Conflict Resolution from the esteemed National Defense College of Kenya. This marked the beginning of his journey into the world of international relations and security. In 2007, he further expanded his horizons, obtaining an MA in International Relations from the prestigious University of Nairobi. In 2009, Simon made a pivotal decision to step into the realm of elective politics, joining the National Resistance Movement in Uganda. His strategic and thoughtful approach to campaigning resulted in an overwhelming victory, securing him a seat in the 9th Parliament as the representative of Bubulo County East in Manafwa District. Within the Parliament, he served as the Vice Chairperson of the Committee on Defense and Internal Affairs, while also being a valuable member on the Committee on Rules, Privileges and Discipline, and the NRM Parliamentary Caucus. While Simon's political journey has been commendable, his contributions extended beyond the political arena. In 2009, he co-founded Link Conflict Consultants, an esteemed security consultancy firm based in Uganda. His dedication and expertise has been instrumental in shaping the security landscape of the nation. As we convene at this prestigious international symposium between Uganda and India, Simon Mulongo's presence symbolizes the spirit of cooperation and mutual understanding between our nations. With his vast knowledge in international relations, security, and politics, he stands as an exemplary representative for Uganda on this global platform. Ladies and gentlemen, let us warmly welcome Simon Mulongo, a visionary leader, accomplished professional, and a passionate advocate for progress and cooperation, as we embark on a journey of enriching discussions to discuss and strengthen the ties between Uganda and India. Ladies and gentlemen, Simon Mulongo.
Wow. So, Crystal, can I see how you're going to help me to flash the presentation? And who's going to be pressing the various, wow, technology. Good, thank you so much. And for that very kind and elaborate introduction. Sometimes the introduction is too good for the person. I'm not sure that I'm going to measure up to that introduction, but I hope I'll try. Yesterday, I had very little time to listen to some of my colleagues making presentations. And from the recapitulation today by Chrysolite, we're able to know and remember what our friend Malaika did present in a very comprehensive way. So this time around, I'm going to handle the legal frameworks with the aspects of policy and institutional frameworks, but without necessarily trying to reproduce what Malaika put for us. Next. Next, please. Yeah, of course, you did look at the definitions of what trafficking in persons entails, but the protocol related to trafficking in persons by the United Nations of 2000 puts the emphasis on issues of prevention, suppression, punishment, in terms of trafficking persons, especially women and children. And this became a landmark in terms of enacting of various legislations that are there to help in terms of prevention, but also in suppression and determination of this very bad activity against humanity. And I managed to look at various other definitions, which the readers may interest themselves with time, where we saw others giving certain stint to the definition, but one which was very interesting was that one of Alexis that talks about obtaining individuals for various deceptive fraud purposes, but for financial gain, because at the end of it all is about financial gain. People force other persons, they may capture them, they may force them in one way or the other, deceive them, but at the end of it all, they want to gain financially out of them. And that becomes a very key component that we need to look at, just money. Next. So the aim is really to look at how these multi-layered criminal offenses open out in various forms, in terms of exploitation of people, forced servitude, sometimes it's extraction of human organs. So when we see people being trafficked, it is not just about forced labor or sexual exploitation. It's also about extraction of human organs, where people go to these other countries or destinations, and at the end of the day, they have their organs removed for financial gain. And that's extremely serious. Now, in my presentation, other than legal frameworks, we're going to look at the performance of these legal frameworks in terms of prevention, protection, prosecution, and the various partnership between individuals and institutions, whether the state and non-state actors, and like on our part, we are actually non-state actors, how we collaborate and to make sure that we stem out this vice. Next. In terms of international setting and regional setting, trafficking in persons takes various forms of legal forms. Can I just see, please get the, yes, as I said earlier, the protocol, the Palermo or Palermo in Italy, Palermo Protocol of 2000 elaborates exactly what human trafficking is all about, and as a vice, how it targets vulnerable people and how they get exploited. And there are other protocols that and conventions which I list out on the right-hand side that are supposed to elaborate, that have come along the way in terms of children, in terms of women, and also in terms of specific actions, legally speaking, to suppress and also eliminate this vice. Next. Next. Yes, still on international setting, we've seen a number of declarations that have come by and laying down of principles that related to protection and welfare of children, the issue of the political declaration by the UN, and also the UN Global Plan of Action. We've also seen other regional organizations like the African Union Commission coming up with the Charter on Human and People's Rights, including an action plan that is supposed to rally African countries on this issue of trafficking in persons, to make sure that they develop municipal laws or domestic laws to fight the vice. Next. And of course, for the India purposes, the Southeast Asia Association has also come up with a very, very responsive mechanism where our sister countries in Asia, Southeast Asia, are supposed to collaborate and work together. And then in terms of India, the Constitution of India has provisions, both Article 23 and Article 24, where they guarantee the rights of human beings against exploitation and also prohibiting employment of children who are underage. There's some kind of noise in the background, but I hope you're able to hear me. Next. Are you able to hear me?
Yes, Honorable, can get you.
Yes.
Okay, but yes. Then, of course, the Indian government has the penal code that is implemented by particularly the police, both at union level and state level, in which they look at various issues, whether it is importation of girl child, selling of girl child for prostitution, issues of penalties that are well elaborated in the provisions of the penal code. So we really want to thank the Indian authorities, the government, for coming up with this. And these, some of them come a long way as back as in the 50s. India became independent in 1947. So by 1950s, they were already tackling this challenge. Thank you so much. Next. Still, in terms of the Penal Code of India, there are various provisions which enhance the drive against the vice. And we have a Trafficking in Women Act and Girls of 56. We have Child Labor Protection and Regulatory Act of 86. We have Immoral Traffic Prevention Act of 1956. This is a very comprehensive law that provides elaborately issues of trafficking in human beings by the Indian authorities. And then we also have the Juvenile Justice, the Care and Protection of Children of the year 2000. Then finally, we have a draft bill that is by Indian Ministry for Women and Children that is supposed to bring together various laws, because as you can see, a number of laws in India are scattered. And so there is a purpose of ensuring that all these laws are approximated, harmonized, and put under one cover. And the draft bill of the trafficking in persons that looks at prevention, care, and rehabilitation is yet to go through Parliament. It has really come a long way. And in 2021, they were able to really reintroduce it. And we hope that it will go through all the way through Parliament so that it becomes the law, an operational law, under one care. As we're going to see later on, it has come under criticism as members of the public, the legal fraternity, and other interested parties give a critique of this draft. But I can tell you that whether they criticize it negatively or not, this is a very important legal framework that we hope will come through in the way it is as much as possible. Next. In terms of Uganda, we have the 1995 Constitution that introduced a number of provisions that aim at ensuring dignity of human beings and protection from any inhuman treatment. We also have a very specific law that aims at prevention in trafficking in persons of 2009 that has a number of clauses that define every aspect of human trafficking, from the initial point of the cycle all through to rehabilitation. Then we also have regulatory, we have also guidelines that go with these that ensure that this law is operationalized effectively in Uganda. We also have some statutory instruments 2005 regarding employment and points out categorically about age and the nature of form of employment with dignity that employers must observe. We also have prohibition of female genital mutilation. I don't know if this makes sense to some people, but those in Horn of Africa, North Africa, and other parts of the Arab communities, women get circumcised, and the circumcision actually is about mutilation. And this is a very bad act that we believe causes bodily harm to women, and we have laws in place to protect women from genital mutilation. For us, it is also part of ill treatment to human beings, particularly women. Then we have the Local Government Act, because in Uganda, we don't have states. We have local governments that form the second tier. And they also make bylaws and ordinances. And we also encourage them to make locally based laws, bylaws, and ordinances to curb the vice of human trafficking. Then the penal code, just like in India, we have an elaborate penal code that talks about all forms of offenses against morality and lawful detention and so on that help us to fight the vice. Next, please. Then, of course, the Children's Act as well in 2016 was when I was in Parliament. We embarked on this to make sure that the children in Uganda are also protected from all sorts of ill treatment, including trafficking. Next, please. Well, I don't have to mention the Employment Act. That's also part of it, part of the labor laws. In terms of evaluation of the performance in both countries, I did a number of analyses to see how the two countries managed to perform. And I also looked at the reports by the State Department in America as part of the international oversight of how we're performing in this area. And apparently, Uganda and India are in tier 2, meaning that we have done quite substantial, but we do not fully meet the minimum standards that is required. This means that despite the laws that are in place, despite the institutional and the policy frameworks in place in support of the laws, there are still gaps that require to be closed. And in terms of India, the ministry responsible for women and child development and Uganda's Minister of Internal Affairs, they have adopted guidelines that are supposed to facilitate in fighting against trafficking in persons. But this hasn't been very easy in both countries. Remember, with the freedoms that we enjoy, in India, we have groups, particularly the feminists, who think that the issue of fighting prostitution is not fair because we take it to mean that all prostitution as a profession is a forced issue. But for them, they argue that it's not necessarily forced. There are women in India who do voluntarily, and even in Uganda, who voluntarily go into sex trade. So why should you treat them under the omnibus provisions of the law? And so they argue strongly against the type of laws that we put in place, thinking we're protecting women and the girl child, but actually on the other hand, we're not trying to free their hands for them as an industry to flourish. So this is some of the areas that we need to see how we can balance the act. Next, please. So the laws in India require that there are amendments. The issue of the definition of the trafficking in section 370 of the Penal Code and 371, 72, and 73, as we shall see subsequently, there are gaps. For example, there is need to include labor trafficking and force and fraud or coercion, so that this becomes complete, because a number of cases in India, some people argue their way out against the prosecution simply because there are gaps within the law. The issue of the need to strengthen the laws on labor recruitment agencies to hold fraudulent labor recruiters criminally accountable. And as my sister Malaika was explaining, we have labor companies in Uganda, for example, who take laborers outside Uganda, but really it is not under the genuine contract that these young people enter into. When they reach their point of destination, they're abused. And sometimes they're just tricked into a contract, whereas the destination is offering something totally different. So we end up having these very formal institutions carrying out the abuse that we're supposed to fight. And so this is very important. So we need to amend the laws in India particularly to make sure that we strengthen those areas that have gaps. Next, please. Now, additionally to these amendments, I looked at a number of other that there are gaps in time. The institution we don't have that, where they become accomplices in the prosecution. You see, when they seek, am I being heard? My internet is being unstable. So what the penalties meted against the traffickers sometimes is very, very minimal, simply because of the gaps that there are in terms of corruption, in terms of investigative capacities, in terms of professionalization of the police or even prosecutors themselves. You find that the investigations, the way they do the reports, the way they craft the crimes or the cases, they leave gaps which are exploited by the defense to get scot-free or even lesser penalties for those who are trafficking in a person. So it's very important. I point out a number of those areas where we require to strengthen provision of stringent internal controls and checks, supervision of those who enforce these laws, those who are supposed to provide oversight, sometimes they have a lot of lacks and they don't do their work very well, simply because the checks and balances are not effective along the way. So this must be done, and we need to do, and we should have to find a way of getting the attention of the state authorities to do this. Next, please. In terms of Uganda, there are a number of gaps as well, despite the fact that they have very good legal frameworks. If you look at the mechanisms available to identify potential and actual trafficked persons, they're almost there. You can find people at the border crossing, and people just feign ignorance or something, and they don't have ability to cross-check the identities of the people crossing. You know, you have your travel papers, fine. Where you headed for? Where is the destination? Whom are you going to see? And so on. You find the people at the borders do not really interrogate the people crossing international borders, including at the international airports. And so some of these people who are smuggled out of the country, they go scot-free. And the issue of refugees. In India, I don't know whether you have this scenario of refugees. In Uganda, we have close to 2 million refugees who come from neighboring countries that are unstable. Now, traffickers target these refugees, and they think they will help them to seek asylum or to help them get third countries to be relocated under either the auspices of UN or other arrangements. And actually, yet they are doing this for purposes of abusing them and exploiting them and trafficking them for ill intentions. So all these are not properly provided for in the laws in Uganda. If you look at the penal code in Uganda, is so lax in terms of prostitution. Yes, prostitution in Uganda is illegal, but then there are organized brothels in Uganda that are done by professionals, and you not even tell that they are doing prostitution work. And because they're so clean, they're so neat, they operate in terms of timings, appointments, and so on. And people go in homes that look like they're just domestic homes or institutions of learning, and yet actually these are brothels for prostitution. Now, the law, the way it is set, it does not include such places. And so as such, there is need. Either we legalize prostitution in Uganda and regulate it, or if we want to maintain the ban, then we must strengthen further the prosecution modalities, including the penal code, if we're to curb the vice. Otherwise, you know, this is one of the oldest trade, as you know. Stopping it altogether may not be possible. So we have to debate that thoroughly and see what is a better option for us to be able to regulate the prostitution, which is taking advantages for the vice of trafficking and ill treatment of women and girl child. Next, please. Yes, I just crafted this for purposes of comparison. You can look at both in terms of constitutional setting, in terms of the parliamentary acts, in terms of the penal codes, in terms of guidelines that both countries have been able to do and provide. This is just for easy consumption in terms of comparison. And as you can see, both countries have been able to do quite a lot in terms of legal frameworks and policies as well. But as I said, there are gaps that require to be closed. Next. Yeah, this was a repeat. Oh, yeah, this is just a continuation. Next, this was just for comparison purposes. Way forward. I think it is very important that having done an analysis of the existing legal frameworks, that we see what can be done. First of all, we need to clarify where there are contradictions or where the lack of clarity is in terms of ordinary crimes that relate to similar ones, like in the abuses that go with the trafficking in persons, issues of kidnap, issues of defilement, forced labor, early marriages. All of these require that we are very distinct when it comes to relationship between the ordinary crimes and the crime committed in terms of human trafficking. The other one is the language. We have a challenge in Uganda. Of course, just like India. India, you're lucky you have Hindi as a common language. In Uganda, we have over 56 different local languages. And we don't have a common language, so to say, except for the English, which is the official working language. So unless you've been to school, unless you've been educated in Western education in Uganda, you may not be able to communicate or be able to understand English properly. So we have to use interpreters. And these interpreters sometimes make mistakes. And the way they communicate to judges or even translate the case into actual crimes committed for purposes of prosecution, some things don't happen or don't get crafted properly. There is also the issue of absence of legal aid policy, like particularly Uganda. I saw in India some NGOs that do this. In Uganda, we don't have a clear-cut legal aid policy to be able to support who should be mandated, who should be licensed, and so on and so forth. Then absence of an established referral system. I mean, we should have a way of having a clear referral system where judicial officers who encounter victims and witnesses may need to further protect them. So the point I was making was that we need to have a clear referral system in which cases can be referred from one level to the other. And we have exhaustion or exhaustive dealing with the case at one stage or prefer going to the next level in case one loses it. Because, I mean, we have an appellate system in Uganda, in courts of adjudicature, just like in India. You start from the magistrate court, you go to high court for judges, you go to the Supreme Court which is the Constitutional Court and then the Supreme Court. But the cases to do with the trafficking in humans do not have clarity in terms of referral system. And as such, we end up losing cases at the primary level, and that's it. Next. We also do not have a witness protection program, which is extremely important. And we attempted to make some law related to that, but each time it comes to the House, it somehow does not go through. But we need to have witness protection, because if we don't have witness protection, then people will not volunteer information, no one knowing that they're going to be protected. The other one is that in India, there's need to provide professional run and well-funded shelters for these trafficking survivors, or even considering sex and people with disabilities. You know, we don't have professionals who have been trained. If you look at the Salvation Army, if you look at the Red Rock, these are the people who have been able to voluntarily train their staff, their personnel. But there are many other people out there who want to help, who provide facilities like shelters, but they're not trained. They don't know how to counsel people. These people who are involved in trafficking, they are traumatized. Some of them have psychological defects that require to be attended to. So if you are not professional, you cannot just talk to people. It's not just about talking to them sweetly, but you have to make sure that you are professionally trained to do that. We also need to bridge the gap in terms of goals in trafficking persons, in terms of protection regimes, and so on. Where we are, though we define trafficking persons in Uganda, is not the same way like European Union does it. You see, in Europe, they look at people who go there as invaders, as economic asylum seekers. Yeah, but they're not just asylum seekers. They could be people who are being trafficked by organized cartels. And so if we don't have a proper breach in terms of gaps in for purpose of interpretation, outlook, and of course, legal frameworks internationally, then we're bound to lose it out. So I want to use this chance to say the Red Rock and Salvation Army Uganda should seize this opportunity to see how best we can create a niche into these gaps so that we become much more specialized, much more cures of these gaps. Because if the government lacks this, if many NGOs lack this, then we should be able to identify this as we are doing now and capitalize on it. And then it will be an area that will be identified with as people who are the first to do that, as people who provide what is not provided for by anybody else. So I think this is very fundamental in terms of this workshop, so that we can explore this further and enhance the type of services that we give out. Next. Yes, finally, we've come to the conclusion, just in case some people are getting tired. Now, the legal regimes in both India and Uganda have come a long way. We have tried so much, but as I stated earlier, being a tier 2 means there is a lot more we have to do. And some of the things that I've mentioned are some of the stuff that we need to attend to. So it was our job to make sure that we can use every means possible, including working with our state structures to have both the law, institutions, and policies enhanced. And then there should also be regular exchange visits and benchmarking for both of our institutions. We should be able to go to Korea and see how they're handling this. Can we also go to Mongolia and see how they're handling this? Maybe because of the weather there, not many people want to go there, but you'll be surprised. You may find so many Ugandans who are illegally in Mongolia, as much as it is extremely cold. How some people manage to find themselves in Argentina or find themselves in UK or Iceland and so on. So in addition to India and Uganda, we should be able to do a lot of benchmarking and use the experience to be able to enhance not only our knowledge, but also our outputs in terms of our performance, but also in terms of supporting the government and making suggestions that can enhance the legal frameworks in our countries, but also in closing the gaps that I've just pointed out. So I think with this, the last one, thank you so much. So that's what it is for now. We've come finally to the end. As you can see, it's about the legal frameworks. As you can see, it's about the nature of the performance of those legal frameworks and the gaps that have been identified, and what we need to do to enhance both ourselves and also to help our governments in both countries. Thank you so much.